Hello and welcome to today's Knowledge Bank Building Safety Reform Update. This session will be hosted by Dr Shaun Lundy, Director of Strategy and Innovation at Tetra Consulting. Also, I'd like to say thank you to Fixflow, who have sponsored today's webinar. If you have any questions throughout the webinar, please submit them via the Q&A button at the bottom of your screen, and Shaun will try to get through as many as possible at the end. Today's session is being recorded. The recording will be available for anyone to watch back later. Also, if anyone missed the session live, then you will also have access to this via email. We will be finishing today's session promptly at 10:59 to allow everyone to join in the 2-minute silence for Remembrance Day. And other than that, I will now hand you over to Shaun.
Thank you, Vicky, and good morning, everyone, and thanks for joining this morning's session. So I've done, a bit of presenting around building safety reform and what's coming up. So you may have sort of sat in and listened to some of those before. I mean, there is a general sort of move towards taking early action, even though a lot of the legislation hasn't actually changed yet. So we can talk a little bit about what that looks like and some of the issues that are arising. And as Vicky said, if you've got any questions, just pop them in the chat box, and Vicky will keep an eye on them. I've got a few slides which I'll work through just to really sort of form a bit of context and give a bit of structure, and hopefully sort of get you thinking around some of the issues that are arising. But I'll try and sort of finish and give plenty of time for questions. As Vicky said, we want to finish promptly to for Armistice and Remembrance Day. So let's make sure we do that. So in terms of what's been happening, there's been an awful lot of activity around fire safety and building safety. A lot of this has been focused, of course, on those slightly higher risk buildings over 18 meters or 7 stories and above. But there's also been a bit of focus on buildings below that height as well, and there's some sort of consideration really around whether buildings below 18 meters present significant risk, and that's a kind of core thing that's being looked at right now. There are colleagues of mine who are working on this to provide evidence for the government to help them understand the risks in all building types, including those lower rise buildings, so that we can be a bit more proportionate in our approach to managing fire safety risks in those buildings. And you've probably been following things since the awful events of Grenfell back in June 2017, 72 people tragically losing their lives, which has sort of prompted a huge amount of activity in terms of reviewing building regulations and fire safety legislation. Dame Judith Hackett leading this, as I'm sure you're aware. Some inquiries going on in the background. So Grenfell phase 1 inquiry was completed back in October 2019, and phase 2 is ongoing. And there's lots of quite sort of startling information coming out of that phase 2 inquiry from evidence that's being given. Everything from some accountability issues through the project, which was designed to sort of put cladding on the outside of Grenfell Tower, to the competency of the fire risk assessor, through to residents raising concerns about how vulnerable people were understood and known in the building, and how that lack of information perhaps maybe have contributed to deaths. So we've seen a number of consultations come off the back of that, including one to do with personal emergency evacuation plans, looking at whether it's feasible to adopt those sort of plans, we call them PEEPs, in general needs accommodation. PEEPs are usually carried out in care settings, supported living schemes, and actually in workplaces, student accommodation, those types of environment. But in general needs, we tended not to do them, but there seems to be a move towards rethinking that. So we're waiting for the outcome of that. There's been an awful lot around cladding, of course, the remediation fund. Lots of money has been made available to remediate unsafe cladding. Firstly, the aluminium composite material cladding, which was similar to the Grenfell Tower cladding, but also then other types of cladding material as well. We've seen a review of the fire safety legislation as well. I'll talk about that in a minute, and also the production of a draft building safety bill, which has been reissued this year and is now going through consultation through Parliament, and we're expecting that to become legislation next year. And that's going to have quite a profound effect on anyone who's managing a building in scope, a building over 18 metres or 7 stories. We've seen a change to fire safety legislation. Again, I'll talk about that in a minute. And also some funding to relieve some of the ongoing costs. So we've seen a Waking Watch Relief Fund released in May, and then that fund reopened actually with an additional £5 million available because of the ongoing delay, if you like, in remediating external cladding material and the persistent requirement for Waking Watch, which of course is costing leaseholders an awful lot of money. So there's been lots of discussion and debate around some of the proportionality, whether the measures that are being put in place are proportionate to the risk, and also how to alleviate that cost. And there's a very, it looks like it's becoming a very successful campaign on the polluter pays. So the basic concept that really it shouldn't be down to leaseholders to foot the bill for some of these deficiencies we're finding in buildings, but actually either the building owners or the developers of those buildings, if you like, the polluter pay type principle should be sought and should be made to sort of cough up some money to help alleviate, what's going on. That's an ongoing campaign. It's gathering momentum, and it's certainly part of the big debate, if you like, in government at the moment about where the money is going to come from to resolve some of the issues we're seeing. On the government website, there's lots of updates there. So you'll see a draft copy of the most recent bill, which is currently being debated in Parliament. They've also published this transition plan as well. I've put the link on the slides, which you can have a copy of at the end of this talk. The government have published this plan to show how this piece of legislation is going to move through the various stages. You can see it looks pretty complicated, but the important bit there is royal assent. So when a bill gets royal assent, it becomes a piece of legislation. So the bill will become an act. And then from there'll be a whole series of implementation stages, which will involve a variety of things, including the creation of a lot of secondary legislation. So secondary legislation is regulation. So the Act usually allows for the creation of regulations. And those regulations, if you like, put the meat on the bones. So the Act is usually articulated at a very high level, and then the regulations a bit more detail. And there's lots of regulations perhaps will be affected by this as well. So we're expecting royal assent next year, probably at the end of the parliamentary session, maybe end of April, maybe a bit later. And then there'll be this process of implementation. So we wouldn't expect many of the requirements to come in until 12 months after that, 2023. And then certainly some of the duties on the accountable person in terms of creating, getting a building assessment certificate and having the safety case report in place and appointing a building safety manager, these new duties and roles that come out of this bill, probably not to 18 months after that. So they are trying to put in place a very sensible process, but as Dame Judith Hackett made quite clear, the expectation here is that duty holders won't wait for the law to become law before they start to implement changes. And as Dame Judith Hackett said here, we expect them to start taking action now. So what we've seen is a lot of activity with duty holders beginning to realise perhaps that they need to enhance the level of information for their buildings in order to prepare for some of these changes, in particular the safety case, which I'll talk about a bit later, and sort of the type of information that needs to feed into that safety case report. In many blocks in occupation, those that would fall into scope over 18 metres, a lot of that information is missing. So really it's a good idea to start preparing for that now, because it would be very difficult to get all that information in place all at once, and it would also be very expensive as well. So spreading the cost and spreading the effort, and also thinking about who's going to provide this service. We all know if you've got a building with an external wall system on, and you've had the issue of getting an EWS1 form completed, we know that there is a severe lack of competent support out there to do that. And the same probably is true for a lot of the fire safety information that's going to be required in buildings. There aren't always the right people out there to deliver that service at the moment. So there's a bit of a competency gap really, that obviously is trying to be filled in the background by upskilling surveyors and fire engineers. And certainly as a company, because we provide a lot of fire risk assessments and fire strategies and fire documentation, we've been part of that process for the last 2 years actually, in upskilling our own consultants to be able to provide more enhanced services like fire strategies, compartmentation surveys, type 4 risk assessments, and so on and so forth. So that's a really key thing to get right. So we had a couple of things happen this year. The Fire Safety Act gained royal assent on the 29th of April, and that will not commence, although that's become a piece of legislation. It won't commence until the risk-based guidance is fully ready, because in the Act it actually talks about the risk-based guidance being used, if you like, as evidence of compliance. So without the guidance, you can't demonstrate compliance against the Act. So until that guidance is in place, we're not going to see that commence. But what it covers really is it's some very simple things, but very important things. The first thing it covers, of course, is extending the existing legislation to cover the external wall system, and includes balconies and doors and windows or anything attached to the external facade of a building. That's an important change because legislation was fairly silent on that. So now it's explicitly mentioned. And also it brings into scope flat front entrance doors as well. So although as risk assessors, we would always take into consideration the flat front entrance door, there was some confusion as to the sort of legal liabilities around the door. So the door is often owned by a leaseholder. And what this Act does, it makes it very clear that whoever owns that door has legal duties under the Act and under the fire legislation. It's in existence at the moment, the Regulatory Reform Fire Safety Order. And if they fail to comply with those requirements, then they could be prosecuted potentially. So the regulator could take action against them, and that's a very important shift and much more explicit piece of legislation to help bring that into scope. I've already mentioned the Building Safety Bill, which we're expecting to get royal assent next year, and the fact, of course, that we're all being urged to start taking action now. It is quite difficult to start taking action now, of course, because we're in a void of no guidance. So we're all waiting for a bit more guidance from the emerging regulator. So the Health and Safety Executive is taking the lead on fulfilling the role of the new building safety regulator. And we're all waiting for a bit more guidance from the regulator and from the ministry, the government as well, to help us understand what good looks like in this area. So the key areas around the bill, of course, the accountable person, usually the building owner, the landlord, and they would have an obligation to apply for a building assessment certificate. And in order to get that certificate would be issued by the regulator for a building that's in scope, a building over 18 metres or 7 stories. They would need to appoint a building safety manager, which is a new role, which I'll talk about a bit later. They would have to pull together information for a safety case and write a safety case report and submit that to the regulator for scrutiny. The bill also creates this new regulator, the building safety regulator. As I've already said, that's the HSE, are going to take the lead in that. And it creates the opportunity to charge for any costs associated with the bill through the building safety charge. And there's lots of discussions going on there at the moment. Some of my colleagues who are much more involved than I am at committee level are feeding directly back to the government on what they consider to be in scope when it comes to building safety charge. As you can imagine, there are probably many things that may fall outside of that charge. So routine health and safety stuff we have in property, which is recharged usually under another sort of mechanism. Things like asbestos, Legionella, general health and safety issues may not fall into scope under the building safety charge, because the bill is very much focused on fire safety, significant fire safety issues, and structural safety, but doesn't include all safety. So that's a kind of, so calling it a building safety charge is probably, it's not a misrepresentation, but it's a much narrower field, if you like, for recharging than we probably realise. So there's a bit of discussion around that. And the same is true of the building safety manager. So under the bill, the building safety manager really is only required to look at significant fire safety and structural safety, but not necessarily manage that broader aspect of health and safety, which all buildings have issues in, that kind of holistic view of health and safety. So there's a bit of a discussion there as well as to whether you'd really want a building safety manager only to focus on a very narrow area, or whether in reality, to get better value for money, you may think, well, actually, I'd like my building safety manager to cover all aspects of building safety, as well as those really serious fire and structural safety issues. So I've shown quite a few of these slides before, really, just to sort of highlight where we are and what's happened since Grenfell. So the media really do zoom in quite quickly on any significant event where fire occurs, and there've been a number of significant events which have almost directly implemented new government guidance. There was this fire in Barking, and a number of fires actually, this wasn't the only one, which involved balconies and raised concern over the material that was used in balcony construction, and also what should be done with that. So rather like an external facade where cladding is present, a balcony can present a similar risk where fire can leap from one balcony to the other if the material is flammable enough. So a lot of focus here on things like activities on balconies, like using balconies, barbecues on balconies and heaters, and also perhaps removing wooden balconies and replacing them with non-combustible material. Of course, huge costs and huge disruption associated with that. And some of these blocks, of course, are low rise, they're below 18 metres. So a big question there as to whether we should be worried about blocks with wooden balconies below 18 metres, or whether we should only focus on those over 18 metres. The Worcester Park fire a few years ago, this was a low-rise timber frame block. So by virtue of its construction, of course, it's not, it's more risky, if you like, in terms of fire spread. But nevertheless, this building was designed to support a stay-put policy. But because defective cavity barriers were present, or barriers were actually missing, the fire was allowed to spread rapidly through the building. And you can see the picture on the right there. That building was pretty much completely destroyed. And despite the stay-put policy, because of this rapid spread of fire, residents left the building fairly quickly, and as a result, no deaths or serious injury. So it's one of those examples, perhaps, that did call into question the validity of stay-put policies in blocks where we're not entirely sure that the level of compartmentation is good enough to support the stay-put policy. So even though it's a low-rise block, it's kind of highlighted that issue, that maybe there is an issue with our lower-rise blocks in terms of the building quality, and we should be maybe spending a bit more time looking at these blocks in a bit more detail to check that they will in fact support the policy of stay put that we want. The Bolton Cube fire was a fire that spread around HPL, high pressure laminate cladding. It spread quite rapidly around the building, very unusually. The Fire and Rescue Service, who had changed their operational procedures as a result of Grenfell, initiated a full and immediate evacuation of this block once they realised that the fire was unlikely to be contained and it was spreading in a very unusual way. There were no deaths or serious injury, but some students, I believe, had to be rescued by the Fire and Rescue Service. And I suppose this sort of reminds us that this external cladding issue is still fairly significant, and it does sort of throw a spotlight on those evacuation procedures. And one of the things that's been recommended from the Phase 1 Grenfell inquiry is for the installation of emergency alert systems, so a system whereby should the Fire Rescue Service turn up to a block and they can see the fire spreading in a way that they wouldn't expect, they can initiate that immediate evacuation by activating an alarm. So it's not a detection system, it doesn't detect fire, it's only operated by the Fire and Rescue Service, and it's done in exceptional circumstances, but it would allow that alarm to be raised immediately and hopefully prompt everyone to leave when they hear that alarm. So a slightly different system than the fire detection system. That's being looked at now. It's not currently a legal requirement in England, but it is in Scotland. Actually, Scotland seems to be a bit ahead of us in terms of fire safety in that way. I mentioned personal emergency evacuation plans early, and I thought probably a good idea just to sort of pick up on the Crewe care home fire, which occurred last year in August. And again, this fire was spread unusually through the building. The building had defective cavity barriers, which allowed the fire to spread. So it moved from compartment to compartment when actually it should have been contained. The Fire and Rescue Service has implemented a full evacuation. So they would have had a sort of staged evacuation, sort of almost a semi-stay put, where residents would have been moved to safe areas. But you can see from the almost total destruction of this care home that there was not really any safe areas in that building. The fire just spread and practically destroyed the building. So again, it continues to raise questions around the quality of our buildings, whether they can sustain the stay put policy which we want to achieve, and also raises those issues around personal emergency evacuation plans as well. And then this year we had New Providence Wharf, which hit the headlines in London, mainly because it's an ACM, aluminium composite material clad building similar to Grenfell. It was criticised actually because it had a waking watch in place, but residents felt confused as to what they should do in the event of this fire. There are also other failures as well. The automatic doors failed, so there would have been smoke detection in the common parts there to and around the building to activate automatic doors, which would have sealed off corridors. And you can see the picture on the right there, and that corridor is has been full of smoke and there's loads of soot on the walls. It would have been very difficult to evacuate through corridors that are full of smoke like that. So lots of issues there, but really I guess the focus is, you know, the fact this building has been waiting remediation for quite some time. It had a waking watch which didn't necessarily function as people expected it to, and a lot of the other fire safety measures in that building didn't function either, in particular the automatic doors, which play a very important part in compartmentation. And then you've probably heard about the Milan Fire in Italy, again over August. This is a building where the commentary on it was that the flames spread through the facade like butter burning, which is quite a scary thought, really. Thankfully, everyone was reported to have evacuated safely, but again, it just reminds us perhaps this is not a UK-centric issue. There are lots of buildings. The supply chain on external wall systems is not limited to the UK. It's European-wide. So this is a bigger problem perhaps than just the one we're facing here in terms of sort of the type of materials we choose to put on our high-rise blocks. And then I thought I'd find a good news one as well. So Redwood House in Solihull was an example perhaps of where there was a fire and the building behaved as we'd expect it to. There was a fire in a flat. It was contained to the flat. The only people that ended up needing medical treatment or needed to go to hospital were those that chose to leave their flat and try to evacuate the building. They had to be led to safety, and of course they got involved in the firefighting effort, which wasn't good either. So it shows really perhaps how a building should perform, and how a stay put policy is the right policy in a building that is well maintained. So in an inspection after the fire, this is a 12-storey block with elderly residents in. The fire service found that the block was very well maintained, very good standards of fire stopping and great standards of compartmentation. So a fire in a flat ordinarily, in probably 99.9% of times, would be contained within that flat and would be able to be tackled by the fire service, making it okay for people to stay safely in their flats while the fire service are getting on with what they need to do. So just looking at the kind of stats around this, you can see here, I think it's just worth looking at this. This has been talked about by government when they're talking about sort of proportionality. They've made this point that the number of fire-related fatalities has drastically reduced from the 80s to where we are now. So we have a lot more people in the population and a lot more people actually living in purpose-built blocks of flats. But actually what we've seen over that period of time is quite a big reduction. And you can see that dwelling fires, the dark shaded blocks here, are the vast majority of deaths. So sadly, and it is really sadly, most people who die in fire will die in their home, which is not great. And you can see the Grenfell Tower fire here in 2017, reported in 2017-18 data, is a kind of outlier, really. It kind of bucks the trend, but actually the trend over the last 10 years has been relatively static. And that's a cause of concern as well, because we don't want to become complacent. So there's a concern actually that there is another, another Grenfell out there, that actually we do need to look at our building stock. Simply because we've been very successful in reducing fatalities, that's not a good reason to stop and become complacent. We need to carry on and make people safe, and importantly, make them feel safe in the place where they should be safe, which is their own home. So just a few more stats here, and you're welcome to go and look at the stats on the website. They're published every year. But if we think about the dwelling fires, 74% of fires occur in houses. So the vast majority of people actually live in houses. So about 20% of people in the population live in purpose-built or live in flats, whether it's purpose-built or high-rise. So the number of fires occurring in purpose-built blocks of flats is slightly higher than expected, so 26% when only 20% of households live there. But when you look at that, you can see that a lot of fires occur in low-rise purpose-built blocks, 17%, and actually only 3% in purpose-built high-rise. But you need to take into consideration, of course, that very few people live in blocks which are 10 stories and above. When we look at fire spread in dwellings, that's a bit more interesting, because I often say that less than 10% of fires spread beyond the room or the flat of origin, and this is true in terms of the data. So if we look at sort of high-rise flats, we can see that there's about 7% spread, so somewhere between 7 and 10%. In houses, bungalows, and converted flats, it's slightly higher at 12. Largely down to the fact that there's poorer compartmentation in those types of buildings. So a purpose-built block of flat is designed to be a set of compartmented units which will contain the fire to the flat, and it shouldn't spread beyond that flat, giving the fire brigade enough time, of course, to come in and fight that fire. And this is this is in September in London. The Evening Standard reported that London passes unacceptable milestone of 1,000 unsafe buildings, and this is based on the number of buildings that have a waking watch in place. And the government has extended the Waking Watch Fund to the 10th of December, but it does close after that, and there is more funding available. And of course, nobody expected waking watches to be in place for so long. They expected buildings to be remediated, any hazardous cladding removed, and then those buildings changed from simultaneous evacuation and waking watches back to their original design, which was for a stay-put policy. But unfortunately, we seem to have an awful lot of buildings which haven't been able to do that for one reason or another, and that may be, it's probably down to access to funds, disputes with developers, and this places an enormous burden on leaseholders in terms of cost. So there's a huge drive to resolve this situation, but 4 years on, we don't seem to be getting any closer. In fact, the number of buildings that are falling in to this regime are going up. And of that 1,000 buildings, I think there's probably about 250, 300 of them which are buildings which have other health and safety, other fire safety issues apart from cladding. So it may be very, very poor compartmentation, or other significant failures, like with automatic opening ventilation, which may not be operating as it should. And that's sort of making that number creep up. So as we look at our buildings in more detail, we're finding more and more issues with them, and that's resulting in more and more waking watches being put in place, which is very, very difficult, very costly, and not a great situation we should be in. So a lot of focus around proportionality and the need for this proportionate approach. So, proportionality, I've put up the ALARP diagram here from the HSE. So ALARP is as low as reasonably practicable, a way of sort of thinking about risk, where either risk is acceptable, tolerable or intolerable, and then what sort of measures we should be putting in place to reduce the risk. So there's a big question at the moment as to what the actual risk is, and we want to be careful that we avoid too much risk aversion, or we avoid excessive cost with no benefit, or even perhaps allocating money to the wrong risk. So getting this bit right, I think, is really important. And Dame Judafakis talked a lot about proportionality. I think the industry is really giving it some serious consideration, and just making sure that we've got the balance right, if you like, in terms of making homes safe as they should be, but also allocating resources and money to the right risk to help that happen. So just a bit of a reminder around the design principles of purpose-built blocks. There's three key things really. Firstly, that there's a high degree of compartmentation. Secondly, a low probability that fire and smoke will spread beyond the flat of origin, and buildings are designed, purpose-built blocks rather, are designed for that purpose. And also that there's a precautionary management principle in common areas, resulting in a low risk of fire in those areas due to that management. Making those corridors and common parts as sterile as possible when it comes to fire risk. And the National Fire Chief Council has sort of reiterated its advice supporting that principle of stay put whenever possible. It did this in 2018 and it hasn't changed its position. The stay put strategy is generally proved over many years to be safe for residents of purpose-built blocks of flats, and the National Fire Chief Council believes it is the correct advice in purpose-built blocks. So there's been lots of discussion around whether we can maintain that, because of course it is a lot safer to have good compartmentation. That's obviously the first principle we should work to, but at the same time perhaps acknowledging that there may be occasions when people do need to be evacuated, hence the phase 1 inquiry recommendation for emergency alert systems. And Roy Wilshire sort of reiterated this point. If you ask any firefighter, so a lot of our consultants who work for us at Tetra are ex-firefighters, and they've been into buildings themselves, and basically the recommendation is to stay in your flat if there's a fire in another flat, because you could be running into smoke, rather like the New Providence Wharf fire where the corridors did fill with smoke. You could run into the firefighter, or the fire itself, or even the firefighters who are trying to fight the fire. So they rather not have the whole building cluttered up with people. They want to get on, fight that fire, stop it spreading, and keep everyone safe. So that's the experience of most firefighters. And as I said, most fires, over 90% of them, are generally contained in this way. Very few will spread beyond the flat of origin. There are some reasons, of course, for simultaneous evacuation. It could be a converted property. Some properties above commercial premises are sort of interlinked into the commercial premises, resulting in them being simultaneous evacuation. Some older properties, perhaps. And the move really to simultaneous evacuation should only be temporary. And where you have sort of compartmentation issues or an external wall system risk, the emphasis should be on resolving those issues. So resolving the compartmentation problems and removing the hazardous external wall system as soon as possible, and then you can revert the property back to what it should be, a stay put property. But of course, some conversions and some older properties will never be able to support a stay put policy, and therefore other measures need to be put in place. And the guidance on this, ARMA, so I sit on an ARMA committee. They contributed to this guidance on simultaneous evacuation, a temporary move to that strategy, the implementation of waking watch and perhaps common alarm systems to alleviate some of the staffing requirements around waking watch. This guidance was reviewed quite recently, but it's really designed only to be a temporary measure, and they are looking at sort of revising it again, really, to support the philosophy that you shouldn't be maintaining a waking watch indefinitely. We must be moving back to what the flats are designed to do, which is to support a stay put strategy, and all our efforts should be in achieving that, really. So that involves everyone. It involves obviously the landlords, it involves leaseholders, it involves managing agents, of course, but also crucially involves government, developers, and anyone else who's been involved in that building and looking at actually getting funding from all sources. And I mentioned earlier about the evacuation alert system as being a recommendation for phase 1 inquiry recommendations. I won't go through that again, but you know, there are British standards for it, but as I said before, it's not a legal requirement at the moment. So in terms of what we'd expect to happen, of course, you know, risk assessment is a key thing. Everything we do pivots around risk assessment. There are loads of questions that kind of arise out of this. What does a good risk assessment look like? What should be covered? The frequencies, and what is an acceptable level of competence? So there is a drive to improve competence in this area. And there are a number of schemes available. I've just made a note of a few of them there. The BAFE scheme, SP205, which is a third-party accreditation scheme for companies. You know, people should be members of a relevant professional body. There's a couple there I've noted: the Institute of Fire Safety Managers and the Institution of Fire Engineers. And all of these things are designed to make sure that the person that walks around and does your fire risk assessment is capable and competent to do it. And there have been a number of examples. Here's one case from Hampshire Fire and Rescue, where a risk assessor, as well as the managing agent, were prosecuted for failing to put in place a suitable and sufficient risk assessment. In this case, the risk assessor was fined £20,000 and costs of £19,000. So that probably was pretty serious for them, and the managing agent as well. Then for property management, they were fined £10,000 and £6,000 costs. And the individual manager was also fined and given a conditional discharge, £1,800 cost. So this all pivoted around whether the risk assessment was suitable and sufficient. And this is a building that had significant compartmentation issues. And the risk assessment didn't address those in any way. So you might have a risk assessment, which is a visual risk assessment, that then makes a recommendation for a more intrusive type risk assessment. That would be okay. But if it doesn't even consider any compartmentation issues, then it's probably not suitable and sufficient. And you know, risk assessors need to be trained, educated, and supervised around passive fire protection. We've certainly done that with all our risk assessors, so that they have enhanced knowledge of the compartmentation requirements in the building. And in summary, the QC, Judge Burrell, sort of pointed out that the job of a fire risk assessor is a highly responsible one. Lives are in their hands, and their judgment is crucial. It's not to be not a job to be taken lightly. And he went on to say it's important to hold risk assessors to account. These are serious breaches. I find it odd that there is no regulatory framework in regard to fire risk assessments, and I think risk assessors. And I think you know, that's really the direction of travel here, is to try and increase the levels of competence all round, really, when it comes to that. We've got a lot of risk-based guidance coming out. So there's a particular risk-based guidance which is designed to tackle that exact problem around external wall systems for blocks of flats, creating a code of practice which will give guidance on undertaking a risk appraisal and assessment of the external wall construction of a multi-storey, multi-occupied residential building. It was due for publication in October, but we're in November now and we haven't seen it, so it looks like it'll probably be later now. But that's a pretty important document, and many of your blocks probably have had external wall system surveys done, and there's been lots of discussion about whether people doing it have the right level of competence. Well, this guidance is designed to resolve that problem. And one of the areas I've been involved in directly is looking at the competency of building safety managers. And as a part of that, the Building Safety Alliance has been created, which the government are supporting. So the government and the regulator have said that they will not operate a register of competence for building safety managers. They will leave that to industry to do, and they've sort of supported the Building Safety Alliance, which was established to do exactly that. So the new Building Safety Manager role which isn't a requirement at the moment, but will be when the Building Safety Bill comes into effect, will provide a register of competence for individuals or organisations or nominated individuals, and that will be publicly accessible for everyone. So it's trying to resolve that sort of competency gap. And one of the things I'm fairly kind of keen on is to see a more holistic view of competence, perhaps. So one of the initial recommendations from Dame Judy Packett was to get everyone involved. So to think about competence of everyone involved. So not just the specialists like the fire specialists and the risk assessors, but also thinking about the regulator. So are they sort of competent to do their roles? Property managers, of course, building safety manager, a particular area I've been involved in, and interestingly, residents as well. So one of the features that's been included there is resident engagement. So accountable persons will have to develop a resident engagement strategy, and that strategy would involve residents understanding their role in preventing fire hazards, if you like, within the buildings that they live. So there's perhaps an education campaign and a consultation campaign that needs to be done with residents to bring them into this sort of overall holistic view of competence. So I've covered off some of these areas already, but of course, there's been questions around getting external wall system surveys done and level of competence for that, and that's hopefully going to be resolved with this new guidance that's coming through. We've seen a real focus on doors in terms of providing that sort of very important and crucial compartmentation in building. So certainly as an organisation, we're doing a lot more door inspections and door surveys to sort of establish that baseline really of doors. And doors are very important part of building compartmentation. So in a purpose-built block of flat, the biggest weakness there is the door. So making sure you've got the right door, that it's got a self-close, that it's a substantial build, if you like, to provide that 30-minute protection, and it has all the relevant bits, intromescent strips and so on, to help hold that fire back. So assessing your door and knowing that you've got the right door is really important, and then sort of maintaining it thereafter is also going to be crucially important. Compartmentation issues, of course, are things that sometimes can be easily visually seen. So as fire risk assessors, there's much stronger focus on compartmentation. A survey that requires more intrusion into a building probably isn't required overly frequently. I mean, it might be required to do what we call a type 4 risk assessment or a compartmentation survey, maybe once every 5 years, perhaps, and then support that with a routine type 1, type 5 risk assessment. But things like this are very obvious to see, even on a type 1, so you can see big holes between compartments, the inappropriate use of this building foam, and poor workmanship as well, where perhaps new services have been run into a building and the fire stopping is just not what we'd expect. So understanding what good fire stopping looks like and getting the right organisations in to do that, and perhaps also considering, if you have any work done on the building, is making it clear on any works order that you require the organisation to make sure that they fire stop to an appropriate standard. And by explicitly stating that, you can avoid those sort of problems of that very shoddy work that was on the previous slide. So just very conscious of time, I want to sort of bring it to an end very shortly, but I just wanted to finish by mentioning briefly the safety case report. So I mentioned earlier it's a new requirement that a building over 18 metres, 7 stories in height, a building in scope, if you like, that will fall under the new Building Safety Bill, will require a safety case report to be submitted to the regulator. And the HSE have issued guidance on this in the form of this safety case principles for high-rise residential buildings. And the government acknowledged actually that the safety case report is probably one of the more onerous responsibilities on the accountable person. It's something we don't have at the moment. So everyone is kind of asking the question, well, what does a safety case report look like and what should it contain? And we've been waiting for guidance. So the HSE, that initial guidance is very welcome because it gives a bit of a framework for what we think it should look like. And it's important to remember that the building safety manager, it will be their job to manage the building in accordance with that safety case report, and of course in accordance with the building assessment certificate, as it's now called. So in terms of thinking about what it looks like, well, we have this sort of golden thread of information, which is a term that's used a lot in construction, and it's been used to sort of identify all sorts of strands of information that may go in to contributing to this safety case report. So we'd expect the safety case report to be a narrative of information, and all of these bits of information contributing to it. So you can see a lot of them there are things you're probably familiar with. There may be things you wouldn't have for your building, like a fire safety strategy or a fire safety management plan, or even a resident engagement strategy. Those pieces of documentation may not exist. So those are things you may want to consider. You may not have done a compartmentation survey on the block, and therefore, in order to provide that assurance through the safety case report, you may want to get one done. So this is kind of like a model, and it sits really on top of your fire risk management system. So do you, as an organization, have a system to make sure you're managing these risks? Do you understand what frequency things need to be done, how to review, you know, how do you consult, and all of those sort of things? And I think really, you know, software is probably going to provide a very strong bedrock for these types of safety case reports. So, you know, using a good software system to help you manage all of this. I think if I was a building safety manager, I'd certainly want to have a system in place to do that. So I've been through all of this. So I'm not going to go through this slide again, but you know, all the things a safety case report should and shouldn't be are kind of contained in that HSE guidance document. And in terms of sort of just picking up on that piece around managing buildings and using software systems, we have a system called Prism. A lot of consultancies like ours do offer these systems. We're developing our system to better align itself with the requirements of the safety case. So, you know, you can provide the evidence that you're managing those risks, proactive task management in terms of getting things done at the right time, and obviously a document library to support that safety case, because as I demonstrated there's a lot of information that will feed into that. And also thinking about new things like the resident engagement strategy, what's that going to look like? And then essential support, of course, for the building safety manager to make sure they can operate in the way they should be. Okay, so I'm going to draw it to a close there and just see if there's any questions. But you know, of course, what's happening next? Well, we've still got a number of items of guidance which are on the way, and we are expecting, of course, the build to gain royal assent once it's gone through Parliament next year. And I think what we'll see from that point is probably a lot more guidance and a lot more secondary legislation and a lot more detail about how we need to implement those changes. So at the moment, we're still in that sort of no man's land a little bit. We're all waiting for a bit more guidance from government, a bit more direction, and hopefully we'll get that over the next 6 months and things will become a bit clearer. So that brings me to the end. Hopefully we've got a little bit of time for a few questions. Yeah,
we've got a couple of questions here. So the first one is from Caroline. She says, when the is it PAS or PAS 9980 is published, in your opinion, is there a risk that some EWS1 surveys will need to be redone if they do not comply with the new guidance?
Yeah, it's a really good question, Caroline, and I think it's not the first time someone's asked that question. I think because you've got to remember, of course, EWS1 form is driven by lenders, so it's really about lending risk. So once that's been completed and the lenders have accepted it, then it should be suitable and sufficient. I think what will probably happen is risk assessors will be reviewing any reports that have been done under that scheme, and they will be making an assessment as to whether they are suitable. In most cases, they should be okay, but there is a small risk that in applying that new PAS document guidance, that they may identify additional issues. So it is a small risk. I wouldn't say it's not going to happen. I would like to say that providing you got the right organisation in to do your EWS1 survey, you should be okay. I have unfortunately seen a number of examples where the assessment wasn't good. It clearly wasn't done by a competent person. Interestingly, an EWS1 form was signed. So there are a few of those cases around, but they're very far and few between. So fingers crossed you won't be in that situation. It's a really good question, though.
Okay. So the next question here is from Harpreet, and they say, are property managers expected to undertake the role of the building safety manager?
That is such a good question. That's such a good question. This is currently being discussed, actually. So I sit on the Institute of Residential Property Managers Health and Safety Working Group. We're looking at that. I mean, there is a competency framework, and at the moment, I think it would be unlikely that most property managers would just automatically have those competencies, because a lot of them are around fire safety and building regulation type knowledge. So there's a question there. I mean, I think all property managers will have a massive contribution to make here. And one of the models that's being looked at is you might have like a sort of super building safety manager, somebody who sits at quite a high level and is very well qualified. And then you have nominated individuals, of which they could be property managers, and they will be supported by that person or that organization. So that sort of distributed model, I think, could work quite well. Yeah, so it's a big thing, actually, and we're still waiting for a bit of guidance on exactly what the building safety manager should look like. And colleagues of mine who are a bit closer to this, Anthony Taylor and others, Anthony Taylor chaired Working Group 8, and there are many people there sort of discussing this very issue, and I'm sort of involved in some aspects of that discussion. So yeah, very good question.
Okay, there are quite a few more questions here, so we might need to follow up via email.
Yeah, I'm very happy to follow up on any questions.
Okay, I'll try and get one more in. If one leaseholder refuses to renew their fire door, who would be responsible, or who would face action? The block owner or the leaseholder? That's from Amy.
So again, that's a really good question, Amy. And I think up until now, we've had quite a lot of difficulty in holding leaseholders to account when they refuse to take action on their door. And the change to the Fire Safety Act, which really changes the existing legislation to bring those doors into scope more explicitly, will really help with that. So I know Hampshire Fire and Rescue, I think they took a case against a leaseholder. It's quite difficult to do, and this change will make it much easier, because it actually says in the Act that whoever owns that door can can effectively be brought to task by the regulator. So it makes that much easier. So we're just waiting for that legislation to sort of come in to commence. And I think once it does, then you'll be able to sort of make those inform your leaseholders of that fact legally, and then hopefully that will result in better compliance around doors.
Yeah, sure. Well, we've got 5 minutes. Okay, I'll try and fit one more question in. So we've got one here, I think from earlier, one of your slides. Karen was asking, what height was the building involved in the barking fire?
So the barking fire, that's a good question, actually. So I believe it was just under 18 meters. That's quite interesting. So good question, actually. Good question. I might have to go back and look at my slide just to clarify, because there were a couple of property fires.
Double check that one.
yeah, but there have been a few on buildings under 18 meters which have highlighted that concern, because all the focus, well, a lot of the focus is on buildings over 18 meters. So 18 meters is a height that's used in building regulations for implementing sort of additional requirements in buildings. So we tend to find that buildings over 18 meters are better compartmented and perhaps have a higher level, if you like, of control. But now we're looking at buildings between 11 and 18 meters. So a lot of buildings over 11 meters, and some of the balcony fires have been those buildings at just over 11 meters. I think Barking was probably one of them, where we're looking at enhanced requirements there. So building regulations has changed, that buildings over 11 meters require automatic fire suppression systems, like a sprinkler system. And also we've changed the requirement around the materials that are used in external walls and balconies for those buildings as well. But that's in new buildings. The question is, what do you do with existing buildings? And that's what's being looked at now. So whether we need to bring existing buildings up to that same standard, because building regulations aren't retrospective. So there's no automatic requirement just because building regulations changes to bring all other buildings in occupation up to that standard.
Okay, lovely. So we've only got 4 minutes left. There's another 5 or 6 questions here. So what I think I'll do is I'll email them.
We can record the questions, can't we, Vicky? And And I'll be very happy to sort of email people back if it's a quick.
Yeah, sure. Yeah, I can send them all across to you in a sheet with their email addresses, and then when you've got time to follow up with them individually, that would be lovely. I will send everyone the recording of the session from today as well, together with your slides from today. And if anyone wants to join us for the rest of our knowledge banks, which are coming up in November and December, then please feel free to go onto the News on the Block website to register. Otherwise, thanks so much for all your time today, Shaun. That was really informative and helpful.
No, it's a pleasure. Thanks for all the great questions. And really good. I can see there's some really good questions there, so we'll get back on
Yeah,
those.
there's some more still. It's a shame. I just don't want to run into the 2-minute silence.
No, of course, no, absolutely not. Yeah.
Okay, well, thank you so much. Thank you to everyone for joining us today, and we will see you again soon on the next session.
Thank you. Bye.
Thank you. Bye.